Your spouse just passed away, there was no will, and now you own your house with your kids. Let's talk about that. So years ago, you might have gone out and purchased a property with your spouse, lived in it from anywhere to 20 to 30 years, and now your loved one has passed away, and you didn't prepare, not only without a will, but you didn't have title correctly. And most people automatically assume that because you're married and both your names is on that title, that the house is automatically going to go to the surviving spouse. And that is not the case if you don't have some magic words on your deed. And those magic words are joint tenancy with rights of survivorship. You see, back in the day when most people buy their houses, they bought it with tenants in common. And so each person owns half of the property. And when someone passes away, when the deed is tenants in common, then 50% of that becomes the estate and the other person still owns the 50%. If you have a will that says, hey, the spouse gets the house, then you'd be okay in that instance because the will would outrank the deed. But if you didn't have a will, then Georgia inheritance laws take over, and all of a sudden you own half of the house and your spouse's estate owns the other half. Now, where this can really get messy is when you have children or even stepchildren. Because if there's no will and you have that tenants in common on your deed, then the inheritance law says that the spouse only gets 1/3 of the estate over here, and the children get to split it 2/3 evenly amongst themselves. Now, if there's one child, you would get to split it 50-50, but if there's more than one, then that 1/3 and 2/3 come into play. And people can find themselves in a hot mess quick because they didn't check their deed to make sure it said rights of survivorship, or they didn't plan ahead and do the will. So let me tell you where this played out in real life with a client of mine. The husband passed away in 2021. There was no will. The deed said tenants in common, and they didn't bother to do probate because mom had lived there for a while and was still taking care of things. And about 2 years later, mom started having hip issues and decided to go get hip surgery. Well, when that happened, she no longer could live in her house by herself anymore, and they were really looking a way to get mom to go into assisted living. But here's the problem. They're getting mom all ready to go in assisted living, and most of the money that mom has is tied up in the equity of the home. And dad over here, because there was no will and they had the tenants in common deed, estate was just sitting over here on the side. Mom and dad had 3 children, and essentially mom owned 1/3 of her husband's portion of the entire estate. So she owned like 50%. She owned 1/3 of that 50% of the house, and the children owned 2/3 equally amongst themselves. So they had to go through the probate process to get dad's estate, like to get somebody established as administrator, number 1. And number 2, thank goodness that the children were getting along, and they worked with an attorney to help them out with this. And so they were able to gift back their portion of the home to mom, so that then when she sold the house and they had that administrator get their letters of administration, mom can sign on mom's behalf to sell the house. The administrator could sign on behalf of the estate. Now, they chose the eldest daughter to be the administrator because mom was already overwhelmed as it is. She's having to move. It's emotional because she has lots of wonderful memories in the house, and she really doesn't want to give up the house, knows she has to, and then they're having to deal with this legal stuff on top of it all. So we got the house sold, and mom got to move into assisted living, and she's happy. But where this comes into trouble is if the kids aren't getting along, because boy, those kids could have dug their heels in. And they could have said, I don't care about mom. I want my portion of the estate. Or if they were minors. If children were under the age of 18, then the court is not going to let you do anything, even if you're the surviving spouse, because they want to make sure that nobody's going to take advantage of those children. So they will actually put a guardian over those children to make sure that their interests are taken care of and nobody's taking advantage of them. What do we do about this to make sure that A, we have rights of survivorship, and B, what we can do if we find ourselves stuck in this situation? To avoid this situation, you can simply go down to the county clerk's office and go see what your title says. Does it say tenants in common? If it does, then you need to get with one of the local closing attorneys. Super easy to change, only costs maybe like a couple $100 to have that title changed over into rights of survivorship. That's number one, that if you're married, go get that deed put in your name in that way. And then you can avoid probate on the house altogether, because all you have to do at that point is sign an affidavit and produce a death certificate to the county court, and they can put the entire property into your name. The other thing you can go do is get a will. That is the easiest way to supersede the inheritance laws and not have to have as much trouble through the probate process. Now, the will does not get you out of it. And I'm not saying that somebody can't object to a will and stop the probate process, but as I see people work through getting their letters of administration versus their letters of testamentary, it seems to go quicker when they have a will and they get those letters of testamentary quicker. The third thing, and this is going to cost a little bit of money, is you can always create a trust. You have to fund the trust, you have to deed everything over into that trust, but a straightforward trust is not really complicated. Around my area, maybe $5,000, but it can avoid the probate process altogether, so long as it's funded. Now, what happens if you find yourself into this situation? Because maybe you had tenants in common on purpose, because maybe it's a second marriage. This is common, it's a second marriage, and maybe your spouse wanted some of their inheritance to go to their children. I mean, that can be a reasonable thing if it's a second marriage. As a surviving spouse, you can probate the court for what's called year support, and this will supersede the will temporarily. It's like pushing the pause button on everything, letting you as a surviving spouse have a whole year's support from the estate to get your bearings down, get a plan together, maybe work with the surviving spouse's children to get a plan together to sell the house, and then you can go be on your merry way. But it gives you time, so you're not rushed and you don't have a bunch of stepchildren coming up and being like, let's go, let's go, let's go. You can petition for the year support to kind of get by. Also, minors can petition for year support if they are under the age of 18. That can be petitioned so that they are supported through the estate as well. The minute they're over the age of 18, they cannot file for year support. Whether you find yourself going through probate, or maybe you avoided it because you have a trust, you do need a dream team to help you get through it. You need a good real estate agent who understands how the probate process works and how to properly market houses that are going through probate. And you really need an attorney as well, so that you make sure you're not missing any of the legal deadlines and steps. You can totally do it without an attorney. I've seen people do it before without an attorney, and I will say that I think an attorney can kind of guide you. They're not going to be there to help you to sell the house, though. They are there for the law. And then you're going to have a CPA, because you're going to have to file taxes on behalf of the estate, whether it's in a trust or not. So having a CPA to guide you through that aspect of things. Now, of course, I'm not an attorney or a CPA. I am a real estate agent who specializes in this. So reach out to me if you're in the state of Georgia and you need guidance on this. I can certainly help you out. And if I'm not in your neck of the woods, because I'm up here in the greater Atlanta area, I can help you find a probate specialist in your area so that you're not fumbling around. Not all real estate agents understand probate, so really try to seek one out who does. I do have some probate resources out there for you in my stand store, so look for the link below. You can go out there, find the probate section, and look at different items that may help you with timelines or how to avoid mistakes. And of course, if you need anything, let me know. And if you like this video, maybe you'll like the next one. I'll see you next time. Bye.